Okay, so I think most people have been brought in from the waiting room. As a quick note, we've noticed that there is a little bit of a delay with Zoom today. So normally the things I say and my mouth usually match at the same time, but it seems to be maybe there might be a slight issue with Zoom. So to start, I'd like to introduce myself. My name is Elena Wolfrey, and I'm the Indigenous representative with the CAS Anti-Racism Committee. I do encourage everybody to engage in their language of choice. The presentation will be available in both French and English via PowerPoint slide. And if anyone wishes to have the material sent to them afterwards, feel free to reach out. We'll be happy to share. As you might have noticed, this session is being recorded and it will be uploaded to the CAS internal YouTube channel. And lastly, there will be an opportunity for questions at the end. Please feel free to either type your questions into the chat and I will read them out for you, or you can click on whatever emoji that is available for you in your Zoom settings, and I will call upon you and you can ask the speakers their questions. So before I introduce our two speakers for today, I would like to invite Ms. Lucia Fevrier-Present, the committee's champion, who will say a few words. Lucia?
Thank you, Elena. Honorable Justice Grammond, honorable justices listening today, Andrew Baumberg, colleagues, welcome, bienvenue. I want to start by acknowledging that we are gathered today on the traditional unceded territory of the Anishinaabe Algonquin Nation. On behalf of the Chief Administrator Anti-Racism Consultation and Action Committee, and in my capacity as anti-racism champion, thank you, Justice Grammond and Andrew Baumberg, for taking the time out of your busy schedule to inform us on the practical ways that the federal court has worked and continues to work out to make our justice system more accessible to Indigenous peoples. To everyone, thank you for choosing to be present today, especially today in support of our Indigenous community at CAS. À tous, merci d'avoir choisi d'être présente aujourd'hui pour soutenir notre communauté autochtone du CAS-SATJ. As we speak, our thoughts are centered on the tragic discovery of 751 unmarked graves at the Merivale Indian Residential School in Saskatchewan. This heartbreaking discovery is compounded by the fact that it follows the discovery of 215 remains at the Kamloops Indian Residential School. My heart goes out in a special way to the members of our Indigenous community at CAS, as well as the wider Canadian Indigenous community. I call on all of us, the CAS wider community, to provide our employees affected by these discoveries with the necessary support as they seek and find healing. Today's presentation will build on the delivered by Elder Dumont a few weeks ago, as well as Monday's presentation by Justice Favre. It promises to be quite informative. Access to justice is an essential element of the rule of law. Again, I thank you for your presence and participation. Encore une fois, je vous remercie de votre présence et de votre participation. Thank you, merci. Now back to Elena. Et maintenant, je passe la parole à Elena Miigwech.
Thank you so much, Lucia. So today we have the honor of hearing from two amazing individuals, Andrew Baumberg, legal counsel for the federal court, and as well Justice Grammond, a judge with the federal court since 2017. Both speakers serve on various committees and are champions for Indigenous issues and increased access to justice. Mr. Baumberg and Justice Grammond have prepared a recorded overview of their works along with a presentation. So I will turn it over to both to introduce themselves and to get started. Thank you both, and I welcome you.
Well, thank you. Good morning, in discussions with Justice Grammond, our proposal was for him to speak about a number of issues. Though given the timing of the event, he is limited internet connection, so he's prepared a recorded video. And it's my understanding he's also on the phone today so that he can intervene or answer questions. So I'll just start the video that he recorded earlier on this week, and then after the end of his video, I'll speak for some time, and then we'll have some questions and answers. And I'll just turn it over in case Justice Grammond has any words he wants to offer before we start the video. Justice Grammond?
No, thanks. I think you can proceed directly with the video. Can you hear me? Andrew, can you hear me?
Yes, Justice Grammond, we can hear you perfectly.
Okay. So now just go ahead with the video, and that's fine.
Can everyone see the video?
To speak about two initiatives of the federal court with respect to reconciliation with the Indigenous peoples. We'll be speaking about our Indigenous language summaries and some initiatives that we've been taking to further the recognition of Indigenous laws. So first, Indigenous language summaries. The context of this is the adoption in 2019 of the Indigenous Languages Act and the more general efforts at revitalization of Indigenous languages. And it seemed as though Indigenous peoples are always asked to translate their own legal concepts or into either English or French, but that there was no translation the other way around. So we said, okay, it could be a good way of getting closer to our public and to further access to justice if we were to publish summaries of our decisions in Indigenous languages. And this would also contribute to the building of a sort of repository of legal materials in Indigenous languages. And in doing so, we would do a modest contribution towards reconciliation. So we've done this in 8 cases so far. So let me give you an overview of how this works in practice. In some cases where the parties involved are Indigenous, and we think there might be a benefit of doing this, we have selected a case for the preparation of a summary. So how is the language selected? So we will ask the parties typically what is the language of the community or the languages. In some cases where a larger number of communities is involved, we have to select a close set of languages. So as I mentioned, we've done it in 8 cases so far. And so we've published summaries in Cree, Dene, Blackfoot, Ojibwe, Oji-Cree, and Innu. Of course, the choice of language is constrained by the availability of translators. So we rely on the Translation Bureau, and they have a list of translators able to translate in a number of Indigenous languages, those that are the most frequently spoken. but not all. So for example, in recent case dealing with a group in British Columbia, there were no translators on that list. So as to the process, what this means is that we have to create a summary of our decision, and typically it will be in the first few paragraphs of the decision. It has to be translated in both official languages, and then it goes to the Translation Bureau, and they will provide us with a translation in the Indigenous language selected, both in written form and in audio form, so that we don't assume that people are always able to read in an Indigenous language, but also, but they may be able to listen to something, to something in spoken form. This, of course, creates a slight delay, but I would say that they're quite quick. It can be done within a week, so it is not a major impediment, although in some cases we may feel that a quicker decision is warranted, so we will skip the translation, as I did in one case this spring. I thought a quick decision was needed, so there was no summary. Now, how do we disseminate these summaries? So they are on the court's website. In some cases, we have issued a press release in both official languages and in the Indigenous language concerned. In other cases, what we've done is that we've put that on Twitter instead of a full press release, perhaps when the case is not does not warrant a press release in and of itself. So then it's available to the public. What's the impact so far of this initiative? The first case where Indigenous language summaries were published was called Whalen, and it was covered by both the CBC and Global News, and even the CBC story included links to the audio recording of the summaries in Cree and Dene. Other cases, to much, have not garnered any media attention, so it's more difficult to say. In one case where the summary was put on Twitter, there were 400 likes, so that's not bad, but we don't have any much more than that in terms of statistics. Again, in Whalen, the case was published in the federal court reports, and the summaries were also published in the reports. So that's nice, but well, who reads the federal court reports? Most people nowadays would look to CANLI when they're looking for a case. So summaries are not available on CANLI yet. Perhaps it doesn't fit in their bilingual scheme, so we'll have to work with them. But it's an experiment. It's a work in progress. And we would certainly welcome any thoughts that people might have as to how we could do this better, or what's the actual impact of the project. The second initiative that I wanted to talk about is the recognition of Indigenous laws. Well, there's a lot I could say about this, but basically, we're a Canadian law court, so we apply Canadian law, but there are instances in which Canadian law refers to Indigenous law. And the most frequent example is elections. The Indian Act says that in many cases, the Council of a First Nation is chosen according to its custom. So we have to determine what the custom is, and in my view, that's synonym with Indigenous law. But that's a substantive issue, and it's it's an issue that we have to decide after the hearing from both parties. But here's the problem. What happens if the parties do not invoke Indigenous law? And in fact, we realized that this was an issue because First Nations or First Nation Indigenous individuals are often represented by non-Indigenous lawyers. And there's a lack of awareness, knowledge, and training about Indigenous law. And so there's a lost opportunity in that, a case that could have benefited from more knowledge about this law, it will be decided according to standard Canadian law principles. Now, it may well be that the increasing numbers of Indigenous lawyers will change this. And I have in mind in particular the fact that the University of Victoria is offering a joint degree in common law and Indigenous laws, and there are initiatives in other law schools in Canada to provide increased training in Indigenous laws. In the meantime, what can be done? So we have an Aboriginal Bar Liaison Committee, and there's a subcommittee on Indigenous law. And one thing we decided to do was to provide tools for lawyers who could be interested in arguing issues of Indigenous laws, or even just to make them aware that this is a possibility. So we, with the help of a number of law clerks, we created a checklist for Indigenous matters, which is intended to make lawyers think about the potential for invoking or proving Indigenous law in matters before the federal court. We are also developing a case list that would provide information to lawyers about this. These will be published on the course website. There is a possibility of appending the checklist to the Aboriginal practice lines in order for it to be further disseminated. So we hope that all steps will make Indigenous law more visible, will make it more visible in Indigenous languages to a certain extent. They are small steps, but we thought that they were important, and that in doing this, we would provide a small contribution to the enterprise of reconciliation. Thank you very much.
Good. So I'll just set up my own presentation, and in the meantime, if Justice Grammond, if you have anything you wish to add, otherwise I'll just go right into my own presentation.
Yeah, just by way of update, since I recorded this, we had a report of the test, the page on our website means the summaries, and apparently we've had about 1,800 visits over the last year, which is good. There's other content on this page, but we believe that it's mostly the Indigenous. So that's not bad. And on Tuesday, I think, that one of pieces was mentioned in media, and it was mentioned that there was a translation in Dene. Earlier, so I thought it went unnoticed, but someone in the media who mentioned the present, a Dene summary.
Good. So this around, and then, well, I'll then begin my part of the presentation, and then we can move to some questions. And I think that the organizers have uploaded both the English and French version of my presentation. But if you want to follow along in just the English or just the French, I think it was uploaded, but it may take some time. Otherwise, it may be a little difficult to read the smaller wording. But before doing an overview of the more specific initiatives that have been completed or are in progress, I thought it would be good just to note that the court's previous and current strategic plan have established a number of long-term goals that are relevant to this practice area, continuing to recognize Indigenous approaches to resolving disputes along the lines of what Justice Grammond was discussing, facilitating hearings in Indigenous communities or webcasts in those communities, better relationships or closer relationships with universities that have expertise, and working with Indigenous peoples to improve the practice in this area, including by reducing the time and costs associated with proceedings. And I'll talk about that a little bit later when I mention an upcoming survey of the Indigenous and Aboriginal bar. Also, for those who may not be as familiar with the federal court's jurisdiction in this area of Aboriginal law, it includes claims against the federal crown, such as title claims, Aboriginal rights and treaty rights, and claims for damages. Also, judicial review of conduct and decisions of federal bodies and tribunals that affect First Nations, Métis, and Inuit, and judicial review of First Nations decision-making bodies. And of course, some judicial review cases come before the federal court, and others are within the exclusive jurisdiction of the Federal Court of Appeal. The court set up a liaison committee to really explore practice issues in this area, and it was established following some discussions with leading members of the bar in late 2004 and early 2005. And they had expressed numerous concerns related to litigation practice, and a couple in particular related to the scope and cost of adversarial litigation, and also the treatment of elders and oral history evidence were two of the top issues that were identified. But there were quite a number, and it was recognized that the general CBA liaison committee structure was really not well suited to work through these specialized issues that would require concerted effort to discuss and to make recommendations. And so the committee first met in September 2005 with representatives from Canadian Bar Association, Justice Department, and Indigenous Bar Association, and later the Advocate Society was also included. And they were open meetings and often very well attended, but some very long meetings. So we had a fairly core working group. And the mandate really was to discuss issues, but really to focus on the concrete solutions, really to work towards implementing changes and advancing underlying issues of reconciliation. And so the minutes since the September 2005 meeting are all on the core website. We've held roughly 2 half-day meetings since then, some years longer meetings, as you'll see in my further slides. And in the last year or two, we've had a few shorter meetings, but virtual, so they're easier to attend. I note in parallel with the creation of this committee, we also created some other specialized liaison committees within the court, for instance, immigration and IP, and it's found really the specialized discussion groups were a lot more practical and appropriate to really work towards solutions. A quick overview of some of the accomplishments, although some of these are really evolving projects that continue to be discussed and updated within the committee. A triage process for Aboriginal law proceedings, the Aboriginal litigation practice guidelines, guidelines for elder testimony and oral history evidence, a framework for appointment of a neutral advisor to the court regarding Indigenous law or traditions, and an option for parties to request an Indigenous language summary, which is what Justice Grammond was just speaking about. So I'll turn now to get into a little bit more of the specifics of these key initiatives. And I'll start with the triage process and dispute resolution. And the current process now, it was a project started under Justice Mandamin's leadership on the liaison committee, was to establish a triage process which would be automated for every new Aboriginal law proceeding that came in. So the registry refers files for timely assessment by the court, even within a few days of it being filed by parties. The court will conduct a triage, and in appropriate cases, informally invite the parties to consider other means of proceeding, and that might include mediation away from the court or judicially assisted dispute resolution. And the court currently has a core group of judges and pro notaries with extensive experience in Indigenous litigation and mediation who are available to assist, whether it be in case management or mediation for this project. Part of the project as well was not just to have an automated triage by the court, but also to allow parties to make a formal request even when they file the application for case management. Either party can make a request. But quite important was the possibility that on consent, the parties could request what could be seen as a standstill order, which would allow them just to start the proceeding, which sometimes is necessary to address limitation periods under statutes, so that they wouldn't lose their rights, but then they could proceed with discussions between parties without the pressure of having the timelines run, and that would accrue to if they proceeded with an adversarial litigation process. And so this triage process and dispute resolution framework is included within the existing practice guidelines. The next project that I'll describe is the court's Aboriginal litigation practice guidelines. These were developed over a few years within the liaison committee. It's quite an extensive document. It's somewhere around 50 to 60 pages now. Our first edition was published in 2009, updated in 2012, 2016, and we're just finalizing the fourth edition, which we're expecting to publish likely by mid-July. And this continues to provide assistance to litigants with clarification of rules and practice options for parties. It's not always possible for the rules to cover every situation, and some parties are simply not aware of the flexibility that's available in the rules. And so each section in the practice guidelines explains current practice and some underlying issues that might be considered by parties, and that would assist them in approaching litigation and understanding what's possible in federal court and and perhaps being more strategic and addressing issues that otherwise might arise and become issues in dispute. So some of the key sections I've listed, just the flexibility in the procedure, the federal court through the federal court's rules, and just highlighting the different rules that are available to parties for different parts of litigation. There's a whole section on dispute resolution through dialogue. And here, providing some of the background issues or underlying issues that arise in dispute resolution, that it's not necessarily a solution for all litigation, depending on the positions of the parties, and just so that they're aware of some of the complex considerations that might arise in engaging in mediation. For instance, costs, consequences under the rules, and offers to settle under the rules that need to be considered, and which will affect their decision whether to do a mediation process. There's a whole section in the guidelines on actions, on judicial review, and then a protocol for elder testimony and oral history. So each of these has a comprehensive set of materials that covers underlying options and considerations for parties. Now, the recent feedback from the bar has been that the guidelines are being used quite extensively, not just in federal court, but also in provincial superior courts across the country, and I think even in some tribunals, specific claims tribunals, and I think others. And so there's very positive feedback from practitioners, and the guidelines are seen as a helpful tool. And I think the feedback reflects the point that it's important not just to have innovations in practice and to be flexible, but also to capture the experience and to have a compilation of best practices and something of an endorsement from the court as to what the court what is done and what it will be seen to accept as a possible option for future cases. For parties, even those who are specialized, just to know that they can present an option in a specific proceeding and have a reasonable expectation that it will be endorsed by the courts for the future, and they can move forward. So I'll move next to an initiative that's captured within the practice guidelines that was included in the 2012 version, but it's the issue regarding elder testimony and oral history evidence. And this is an issue that was raised from the earliest days of the liaison committee, and it concerned the treatment of elders in courts, not just federal court, but courts across the country, and the manner of reception of oral history evidence and just the pre-trial procedures for oral history evidence. These were identified as matters of particular concern within the bar, both public and private bar. And so there were quite a number of meetings where these issues were discussed following the creation of the committee, and eventually we decided to hold a 2-day symposium on oral history and the role of elders in federal court proceedings. And we had quite a number of participants, both from within the court, outside the court, including 9 Indigenous elders from across the country. And following that symposium, the elders in turn invited members of the federal court for a 2-day dialogue in 2010 at Turtle Lodge, which is a sacred lodge of the Anishinaabe peoples on the southern tip of Lake Winnipeg. And I just have one small quote from what was a very long and important meeting when the elders stated, "We believe that in coming together, we can create a system of justice second to none in the world." And it was an important step, I think, for the courts and for the Indigenous bar in the process of developing practice guidelines that would be appropriate for Indigenous elders and elder testimony, and We continue to work within the committee over the next year and a half, couple of years or so, with the group of Indigenous elders and other members of the Indigenous Bar Association to develop a protocol that was then incorporated into the second edition of the practice guidelines that were published in 2012. And among other things, the revised guidelines really emphasized the importance of community and elder assistance in resolving legal disputes. Now, the 2012 version of the protocol was used quite extensively in the years that followed, but it was not intended to be a closed framework or a definitive framework. And so practices in the federal court and other courts have continued to evolve and build on that, and other innovations in other courts. And so the committee thought it appropriate to take another look and see what had happened in the last, in the intervening years, and conducted a comprehensive review of how all the testimony and oral history have been handled, both in federal court and superior court cases across the country, and to compile a summary of case management orders and trial directions. And there's been a lot of innovation and some very good work, but it was not easy to access, and certainly not something that'd be easy for litigants in other cases. And so cases were compiled, and work was done on a revision to the protocol, which was finalized early this spring, and they are being incorporated into the fourth edition of the practice guidelines, which looking to publish likely in the next few weeks. So the update this year provides a compendium of how the protocol has been applied, and provides a lot of different options. So it's not meant to be directive, but to provide options on for parties to choose from that is appropriate for their case. Next, jump to the framework for appointment of a neutral advisor under Rule 52. And just taking a look here. I think it's important when looking at Indigenous litigation in federal court or other courts to recognize that it occurs at the intersection between different languages, different legal traditions, and different world views. And for this reason, I think there was a suggestion from a member of the private bar that the court look at using Rule 52 as an option to find someone who could act as an advisor to the court to help navigate this intersection. And some issues are seen in court that are the work really of expert witnesses and formal evidence to be submitted to the court. There are also many contextual issues that are not strictly in dispute, but are important to facilitate the court's work in a case. And I'm reminded here of remarks by Justice Michel Shore. I think he's actually here on the call, who's often spoken of a party's gallery of portraits, the dictionary of terms, and an encyclopedia of references. And it's a whole backdrop to the party's approach to life, to their litigation, to disputes that is something that it's at times can be a challenge for the parties in the court to grapple with. And so the proposal here was to rely on Rule 52 of the Federal Court's rules to allow for the court to appoint a neutral advisor regarding Indigenous laws or traditions, and to assist in matters related to the reception, interpretation, or application of Indigenous law. And so the work of the committee here was to develop, well, first to engage with Indigenous Bar and the CBA and Justice to really look at how the rule might be used, and then to develop a framework. And so we've reached an agreement on appropriate framework and protocol for inviting an assessor, and the next step is for this framework to be launched with the 4th edition of the practice guidelines. And we're just at the stage of creating an advisory committee, which would be available as needed if the court wished to appoint a neutral assessor. There'd be a protocol for requesting recommendations from an appropriate person through an advisory committee. So at this stage, I'll just go to some of the ongoing committee work and emerging issues that are on the committee agenda. As I mentioned, we have the 4th edition of the Aboriginal Litigation Practice Guidelines, which includes the updated elder testimony and oral history protocol. We are in the process of constituting the Indigenous Law Advisory Committee for the Rule 52 assessor process. There's an active subcommittee looking at ways to really make more space within the federal court for Indigenous legal traditions. And I think that a matter Justice Grammond spoke about, including the council checklists and an Indigenous law list. And the committee is also looking to launch a survey on scope and cost of Indigenous litigation. And this was an issue that was raised early in the work of the committee and has been reiterated from time to time. And I might note here that whereas many cases in federal court are measured with a timeline either in months or sometimes in years, a typical judicial review may begin and end within a year. Some Indigenous cases, particularly complex actions, are sometimes measured in decades. There are cases which 20 years from the time that they're filed as a statement of claim and go through all the discovery process and pretrial case management and through the trial and a decision. And so there's a need to really look at some of the underlying issues that affect the scope and cost of litigation, and a need to develop some solutions that are appropriate. And so we're at the final stages of a survey that will be launched likely in mid-July, which will really provide an opportunity for the members of the Aboriginal Bar and Indigenous Bar and the court to express their views on issues that really require attention and to suggest some solutions, and then the feedback will come to the committee for its fall meeting. And I think the last point I would touch on in terms of ongoing work, the Truth and Reconciliation Commission calls to action have been discussed in meetings the last few years within the committee. Last year, there was a recommendation to build on the work of the committee of the last 16 years and to develop a more formal reconciliation action plan that would have more concrete deliverables in a sense, or timelines, and identify resources, what was planned and why, and who would work on it. And so that's something that is underway now, is development of an initial draft framework. And I think for that point, I might just do a new share of a screen of what's been done in other jurisdictions. And in particular, I've shared a screen here from the Federal Circuit Court of Australia. They've had a formal reconciliation action plan now, I think, close to a decade. I think they're on their 3rd edition. And it sets out a fairly transparent and formal framework for both the history of what they've done and their priorities for relationships. They have 4 key areas that they focus on: relationships, respect, opportunities and governance tracking progress and reporting. And so we're not obviously going to follow exactly their model, but it provides, I think, a good example of what other courts in other jurisdictions are doing in similar contexts. And I'll just jump here to the equivalent of CAS for Australia. Their administrative arm to the courts has a separate reconciliation action plan, and it really provides a framework for the administrative side. And I think that's something really that CAS should look at as a possible model to follow, and really to expand just the level of engagement in this area, and have a more transparent projects both internally and externally in this area. The organization in Australia that oversees this is called the Reconciliation Australia, and they have 4 different templates that they provide for institutional reconciliation action plans. I haven't found something similar in Canada that provides sort of the institutional focus for development of a formal reconciliation project. But anyways, I'll leave it there in terms of a reconciliation action plan. It's something it's way and will require considerable work, and I think it's something that really needs more work to be done. And I think with that, I'll stop the screen share, and I'll perhaps put it up at this stage, unless Justice Grammond, you wish to make any further remarks. I could simply open it up for any questions or comments that might arise from our presentations.
So no, let's just take the questions.
Okay, wonderful. So thank you very much, Andrew and Justice Grammond. We do have one question that has come in French. So Isabel Simon is going to read that out. I know Justice Grammond and Andrew, you're both bilingual. So Isabel, if you could please read that question out.
Yes, of course. So the question is, bonjour. Je me demandais si le Indigenous law, donc le droit autochtone, n'est pas de connaissance judiciaire et donc pourrait être appliqué par la Cour d'office. Merci, et c'est Madame Andon qui demande ça.
Oui, alors je peux peut-être répondre à cette question-là. Évidemment, c'est une question qui relève davantage du fond, mais qui est du fond des litiges, mais qui est reliée aux certaines des préoccupations là, dont aujourd'hui. C'est vrai que c'est pas toujours possible. Et la raison principale, c'est que la Cour est composée de juges qui, généralement, n'ont pas de formation en droit des Autochtones. Alors, il y aurait un risque de prise de connaissance judiciaire du droit autochtone mène à sa déformation, mène à l'utilisation de stéréotypes. Et j'ai abordé cette question-là dans une décision que j'ai rendue là, plus tôt cette semaine, Louis contre... je pense que peut-être qu'il y aura des cas où ce sera possible, et peut-être dans le futur, ce sera davantage faisable, mais de façon générale, la politique de la Cour, c'est d'exiger la preuve du droit autochtone. Il ne faut pas oublier aussi souvent que le droit autochtone, ce sont des résolutions adoptées par les conseils des différentes Premières Nations, et évidemment, il faut que ces nous soient... on ne peut pas les... Peut-être répéter juste un sommaire en anglais. The question was whether we could take judicial notice of Indigenous laws, and I indicated some of the important pitfalls in approach, including the fact that we have, as a court, we don't have the institutional knowledge, and I mentioned I addressed this issue to some extent in a decision I issued earlier this week called Louis and
Justice Grammond, you just cut out for a moment there.
Sorry, I didn't hear you.
I believe you just cut out for a moment there. We lost you a little bit where you started saying the decision.
Oh, yeah. I mentioned that I addressed these issues in a decision I issued this week called Louis versus Minister of Indigenous Services about judicial notice and the requirement for proof of Indigenous law.
Wonderful. Thank you so much. The next question that we have, and I remind everyone, please feel free to hit one of the reactions, and I'll be scanning if anyone would like to ask a question themselves, or if they feel more comfortable, please feel free to type your question in the chat. The next question we have, so just scanning down. Lucia asked, as it relates to truth and reconciliation, more specifically, the development of a formal reconciliation action plan, is there a timeline by which the federal court expects to achieve this objective?
I don't think we have a fixed timeline. I think the goal is to have at least a draft available for the fall that can be discussed. But we haven't set a fixed timeline, simply a commitment to create one. So I think we're aiming to have at least a draft and possibly something that can be published after discussion with this fall. But I think we'll go one step at a time and see how the discussion unfolds. But Justice Grammond, it's Fable, if you wish to jump in. I don't know if you have any other further in terms of a proposed timeline.
No,
Okay, so the next question, do you expect to see all decisions being issued in Indigenous languages in the future?
that's a good question. I don't have any fixed views on this. At some point, we'll have to look at the cost of doing this. But as I mentioned, I don't. It's not prohibitive. The issue will be the selection of cases. I'm not sure that all decisions we make and issues deserve translation, in the sense that they're not necessarily issues that have a jurisprudential interest. So there are many factors taken into account in deciding which decision should be translated, and I don't have. I would certainly welcome any comments on that. But at this point, I think, at least with respect to my decisions, I'm asking myself, is there some general interest beyond the parties to the case is to build this sort of a repository of jurisprudence in Indigenous languages? Of course, it's not always in the same language, so it may end up being scattered. Not everyone who speaks an Indigenous language will be able to read every decision, although it seems that Cree is the most frequently used language in this project. So it's a good question, but I don't have any definitive answer. And if we get feedback as to how this project is useful, what we could do better, how we could their selection of languages, that's most welcome.
Okay, thank you. And the next question is, I know that certain courts perform smudging before starting their court proceedings. Do you see that as something that the federal court might adopt?
Perhaps Andrew will have something to say about this, because I personally haven't seen any of this in my cases, so it's a little bit hard to tell. But I wouldn't have any objections to this done before the opening of court or in some proper way. Assuming that we return to in-person hearings, of course. Andrew, did you?
The subject of special ceremony at the beginning or around a hearing is included in the practice guidelines, and so it is an option that's already including issues around, for instance, swearing an oath on an eagle feather or other options. So it is already included quite a number of points within the practice guidelines, the section for actions and the conduct of trials. There's a number of pre-trial conference issues to address, including things such as ceremony language to be used and so on. So I think it's already addressed within the guidelines.
And I think it's also being considered on a case-by-case basis as the guidelines allow for. So I think various judges have incorporated such practices in the proceedings presently, and will likely continue to do so.
Wonderful, thank you. And thank you, Justice Fievel, for jumping in. I have one other question that is in the chat. We are nearing the end, so if anyone has any last minute questions, please feel free to send them. The last question that we have. Andrew, you spoke to several excellent vital initiatives. What would you say is the greatest obstacle or challenge in making advancement on these planned initiatives?
Sorry,
I think the question is what is that I spoke of a number of initiatives, and what's the greatest obstacle? I think partly it's I mean, the members of the court and the members of the bar who are involved in the committee. There's a lot of work to be done, and it could almost be a full-time job working on these initiatives, and so it takes time to work through the discussions on the oral history, discussions on a reconciliation action plan, and so I think it's partly just available time and resources. Judges have hearings, full-time hearings, and I have other projects, and the lawyers on the committee, they're great lawyers, and they have full-time client practices, and so we're trying to really make progress with sometimes limited time to really be the most efficient and prioritize issues. And so for me, at least, I see that part of the challenge in moving forward. We have quite a number of initiatives, a survey, practice guidelines, a number of subcommittee discussions, and it's I find it challenging sometimes to keep on top of all the logistical information and process. But I think there's a great willingness and support from the bar, the public bar and the private bar, and the court is very committed to the work that's going on here. And so I see a lot of room for progress. And I raised the issue with the Reconciliation Action Plan for the Australian equivalent of CAS. I think that's a model that should be considered, I think to widen the scope of engagement within the Courts Administration Service as well.
Wonderful. So those are all the questions that we have. If anyone thinks of a question after the fact, I'm more than happy to connect you either with the speakers or to get the answer and send it to you. I want to thank everyone for taking the time to join us, and especially Mr. Baumberg and Justice Grammond for speaking to us today. I know they put a lot of time into preparation into this presentation. I want to remind everybody of the additional activities that will be going on for this month. At the end of the month, we will be having a brilliant author who will be presenting to us, Mr. Rice. And as well, we still have the ongoing times that if anyone wants to watch the 2 movies that we suggested. One was the PASS system. I'm trying to recall the other one. Diana's here. She can say, but we asked everybody if they want to watch either one or both of those movies and get together and have a chat about what you watched and thoughts on it. And those things will also, those invites have also been sent out. If anyone has any questions, again, please feel free to reach out to me, and I thank everyone for taking the time to join us here today. Have a great day.